to the crime. The Commonwealth did see some pairs of footwear at that time. 17 months later, in November of 2014, the Commonwealth sought a warrant to go back to Mr. Hernandez's residence to seize 3 specific pairs of shoes. It's our position, Your Honor, that the information set forth in the warrant affidavit is simply stale. It does not provide a basis for there to be probable cause that those shoes would be found in that residence 17 months later. Your Honor, there's just 2 things in the Commonwealth's, well, there are 3 things in the Commonwealth's response that I want to address. Number 1, Your Honor, the Commonwealth's response states repeatedly that the shoes were in a closet in June of 2013. And in fact, that's not what the affidavit says.
Right, it was a question I had actually.
So on paragraph 56, paragraph 59A, and then Appendix A is the photograph, which is now in evidence, Your Honor. These 3 pairs of shoes were on the floor of the basement. They were not in a closet, according to the affidavit submitted in support of the search warrant application. I think that's significant. Secondly, Your Honor, the Commonwealth refers in its response to there being an 11-month gap. I submit it's a 17-month gap. The only thing that happened within those 17 months is a rather vague conversation between Ms. Jenkins and Mr. Hernandez on Christmas Day, I believe, 2013, where Mr. Hernandez asked whether his clothes were still in the house. Ms. Jenkins responded. The court has the language of the conversation, which was a recorded jail call. But basically, Ms. Jenkins says that she was going to move his shoes to make more room, but she didn't. That was in December. So that's the only thing that happens in 17 months. So in June of 2013, the shoes are on the floor in the basement, and they say 17 months later that they're in the house and we should be able to go get them. None of the case law that the Commonwealth has cited supports this kind of a gap, Your Honor. They rely on this case, I think it's called Bly or Blythe. It's the case, it's a 4-month delay involving chainsaws. But even in that case, Your Honor, the appeals court noted that there was evidence of continuous criminal conduct in the interim involving stolen TV sets. So it wasn't just, they didn't say 4 months was okay. They said 4 months where you've got some evidence of continuous criminal conduct. The case I just looked at, which I had not seen before, McLeod, which is a decision in the Superior Court by Judge Liu, it looks like the length of time in this case was 2 months. So I've not found any case, Your Honor, involving any delay of this kind of magnitude between the information and the request for a search warrant, absent as evidence of continuing criminal activity in the interim, which isn't here, or some other information close to the moment in time when the warrant is sought, which would provide probable cause that the items are there. That's simply lacking here. The law is clear that the information has to be timely. It has to be close in time to when the warrant is sought. In this case, that critical element of the application is simply lacking. The information in that application is stale. The clerk magistrate in the Attleboro District Court should not have issued the warrant because based on the 4 corners of the application and affidavit, probable cause was lacking, and therefore the court should suppress any and all fruits of that search. Thank you, Your Honor.
Yes, Your Honor. Thank you.
For your argument, I just wanted to clarify in the opposition brief, you referred to the pairs of shoes in the closet.
Yes, Your Honor.
That were material evidence, and then you go on and said the affidavit recited, etc. I thought the search warrant dealt with items that had been photographed in the basement.
Yeah, that's true, Your Honor. And then later there was the movement of those items on the 28th of June to the closet. You know, that was that other photograph So they were actually in 2 locations. But just on the issue of staleness, I would suggest that it doesn't appear to be stale in the facts of this case, where you have a durable item such as shoes in a home where there's the later conversation with, one, they're observed in the home, 2, the photograph, or later in the closet, the conversation that he has with Shayana Jenkins. That was in December of 2013, so that was some 6 months later, but at that time, they specifically talk about his items. Now again, Mr. Hernandez is the one who owns the home, and these were obviously men's shoes, and he says, "You still got my clothes at the house and shit?" And she says, "Do I still have what?" And he says, "My clothes still at the house?" She answers, "Where do you think they are?" He says, "I don't know." She says, "I mean, what do you think I'm doing? I don't understand. I really don't understand. Like, where do you think your clothes are? Your clothes are exactly, I mean, that is your house. Your clothes are exactly where they're supposed to be." He says, "Mm-hmm." She says, "I thought about moving your shoes to give you some more room, but I mean, I left them." So I don't think it could be more explicit. 1, it's his house. 2, these are his items. 3, there's specific conversations about items in the house belonging to his clothes, and then his shoes, and then she's indicating, "I specifically left them." There'd be no reason to believe that the shoes now would have been, moved on from his house, and obviously even the co-venturers, they were in custody at that time. The idea that maybe they might come back and try and recover certain items. So respectfully, I would suggest the argument should fail on the issue of staleness, that it actually indicates that an intention to maintain these in the place until he decided to do something different with them.
Very briefly, if I may, Your Honor. Once again, Mr. McCauley has referred to the fact that these shoes were later photographed in a closet. Well, if they were in a closet, that might be different, but that's not in the affidavit. There was nothing in the affidavit about shoes being in a closet, and therefore, that's got nothing to do with whether or not the affidavit establishes probable cause. Secondly, Your Honor, as far as that conversation, number 1, it's 11 months before the search warrant is sought, and number 2, Mr. Hernandez asks about clothes. He doesn't ask anything about shoes. It's Ms. Jenkins who brings up the possibility of moving shoes. That's the only mention of shoes is by Ms. Jenkins, and it's in the context of maybe she's going to move shoes to make more room for herself. So I don't think that that helps the Commonwealth's showing one whit, Your Honor.
Thank you. The defendant is seeking to suppress the fruits of the November 24, 2014 search that was undertaken pursuant to a search warrant on the grounds that the information set forth in the affidavit in support of that warrant was stale, and therefore the application did not establish probable cause to believe that the 3 pairs of shoes sought would be present at the defendant's residence on the date of the search. As the Supreme Judicial Court has stated, whether the facts in the affidavit are recent enough to justify a finding of probable cause must be determined by the circumstances of each case. There is no bright-line test for determining whether information is stale. The closeness in time of the information required to establish probable cause depends largely on whether the items sought are durable and of continuing utility, or are a readily disposable commodity like drugs and or contraband, other contraband, which is likely to be consumed or destroyed. Several cases the defendant relies on do not support the proposition that the information in the affidavit is too stale to support issuance of a warrant. In United States versus Prideaux, Prideaux, hyphen Wentz, W-E-N-T-Z, a Seventh Circuit case cited by the defendant, the court dealing with the search warrant for child pornography on the defendant's computer specifically declined to find that evidence that is 2 to 4 years old is stale as a matter of law. In that case, the record suggested the images may have been at least 4 years old. The court held that the government's failure to find out the dates on which the pictures were uploaded supported a finding of staleness in that case, because the government could have easily obtained the information by contacting Yahoo. In United States versus Greathouse, the District of Oregon case cited by the defendant, the court was again dealing with a search warrant for child pornography. In ruling that a 13-month delay was too stale, the court stressed that the assumption that child pornography collectors maintain images for long periods of time does not account for the frequent upgrades in computer systems. The court noted that over the course of a year, it's highly possible that hard drives or entire systems could be replaced and illegal material lost with the old system. An incriminating image on a computer hard drive in the defendant's possession is quite different from the sneakers that are the subject of the search warrant at issue. Here, the search warrant indicated the shoes were in a basement bedroom on the date of the initial search warrant executions in June of 2013. The affidavit further stated that in December of 2013, when the defendant was speaking to Ms. Jenkins and inquiring whether she still had his clothes at the house, she responded, "That is your house. Your clothes are exactly where they're supposed to be." And she further indicated she had considered moving his shoes to make more room, but left them in place. The affidavit provided the magistrate with information that Ms. Jenkins still lived in the residence, that it was still owned by the defendant, and that the defendant himself had not been present in the residence since June 26, 2013, and that neither Mr. Wallace nor Mr. Ortiz returned to the residence after they left wearing sandals. Items that are durable and of continuing utility are reasonably likely to be found in the defendant's home after a crime, as the SJC has stated in cases like Commonwealth versus Gray, and that's particularly the case where the defendant or a person living in his home, like his fiancée, is not likely to dispose of them because they are not inherently incriminating. Sneakers are an item of continuing utility. Indeed, in Commonwealth versus James, the SJC specifically referred to sneakers, as well as clothing and other items, as objects that are durable, of continuing utility, and not inherently incriminating to possess. The affidavit at issue indicates that the sneakers appeared to be in good condition, allowing the magistrate to reasonably infer they were not likely to be discarded. And that the retro low sneakers had only become available for purchase to the public about 3 weeks prior to the murder of Odin Lloyd, and therefore those were essentially new shoes. There was also no reason to believe that the condition of the sneakers would have deteriorated by use, making it likely that they would have been discarded, because there was evidence before the magistrate that neither Mr. Hernandez, Mr. Ortiz, or Mr. Wallace were in a position to have won them down over the intervening months. The magistrate could have drawn the reasonable inference that the shoes at issue would still be found at the defendant's residence, where, given the statements made by his fiancée 11 months earlier, given his lack of access to them, given the fact that she in effect expressed an intent to keep his clothing and other belongings intact at the home, and there is no indication in the conversation that Ms. Jenkins perceived the sneakers to be incriminating. Under all these circumstances, the court finds that the information in the warrant application was not too stale to support issuance of the requested warrant, that there was a substantial basis for concluding that the shoes likely, on the specific circumstances of this case, would be found in the defendant's residence on the date of the search. Accordingly, the motion to suppress, based on the four corners of the warrant, is denied. The denial of the motion to suppress doesn't resolve the issue of the relevance of the evidence. It's not clear whether the Commonwealth is seeking to introduce this evidence to counter the defendant's Bowdoin line of questions, so that the jury can understand that once the Commonwealth discovered it had overlooked material evidence in the earlier searches, it immediately tried to rectify that error, which may be relevant given the issues that have been raised with respect to the investigation, or whether, as the defendant suspected, indicates it suspects, the Commonwealth is seeking to use this as consciousness of guilt. So before the evidence is let in, if you could just indicate the purpose for which you're seeking to introduce it.
The purpose, Your Honor, is the police did discover sometime after that there were items. I think the evidence would show that in March of 2014, there was the final report relating to footwear. And as a result of the footwear impression was unknown at that time. Further evaluation of video indicated that the Ortiz and Wallace, when they arrived, they had certain footwear. When they left, they didn't have that footwear. That caused us to go back and then review the video with regard to the home surveillance video and other evidence. That led to the understanding that there was shoes in the home, in that closet picture, that were then identified as being consistent with the shoes that all three defendants were wearing at that time. So those two, and that's already in evidence, there was the initial photograph taken on the 22nd of June that shows the photos in the closet, showed those three pairs of shoes in the closet. On the 28th,
June 22nd.
I beg your pardon, Your Honor. On June 22nd, they weren't.
On June 22nd, the photos were of the three shoes in the basement.
Correct, and I'm sorry, I misstated that again.
And so June 22nd, the photos of the three shoes in the basement.
Correct.
And the photo of the shoes in the closet that has come into evidence, that was taken when?
On the 28th of June. And that shows that they were now back, or they were moved to the closet area.
And that's June 28 of 2013.
Your Honor.
Right. So I guess, but my question is separate. My question is, there are conceivably two purposes that the Commonwealth may want to get into evidence that the shoes weren't there. One would be, as soon as we realized we hadn't taken those shoes on June 28, we promptly went to get them so that we would have them for you. We didn't purposely not take them. We didn't not want to do whatever analysis. We did whatever. We didn't take them on June 28th for whatever reason, and when we realized we should have or didn't, we went back to rectify it, and that's one purpose. And that would and a second purpose would be the defense has speculated that the reason you want it in is not for that purpose, but is for as conscious of guilt. So I just want to clarify which.
Well, I don't know. That I would have to pick one. I'm suggesting it's both, Your Honor. One is...
Well, on the conscious of guilt, what evidence is there that would support the inference as required that it was the defendant committed that act, either directly or indirectly?
Well, I think there's a lot of evidence that would suggest that he used Shayana Jenkins as his agent to destroy evidence in the case. Dispose of, destroy, make evidence disappear. And
In addition to the weapons, is there other evidence in addition to the?
well, there's statements, Your Honor, in the House of Correction that he said something to the effect of, "She does what I want," and he was directing her to give money to Tanya Singleton at the time where he had just recently had told her not to talk, and of course we know she didn't talk and then was held in contempt. So with regard to the statements or the evidence, while he was at the station, you'll remember, he sent the first text to her about getting rid of the black box. And then while at the station, he then sent another text to Wallace about, you know, here's Shay's number, keep your phone on and charge. And then at that point, Shayana Jenkins, indicating she was going home, didn't go home, went to the Franklin, to the area as shown by cell phone records, to the Franklin apartment. Then from there, in the middle of the night, with her child on board, drove down to Rhode Island, where Wallace and Ortiz, shortly after the police came to the 22 Ronald C. Meyer, the defendant called Wallace, and of course the cell phone records show his phone immediately leaving Franklin and traveling back to the direction of Bristol, Connecticut. Well, after the connections between Shayana Jenkins and Wallace, they turn around and they meet in Coventry, Rhode Island, at which time Ms. Jenkins makes a withdrawal from an ATM. And there was two other withdrawals from ATMs.
Right, but if, I guess I'm targeting the shoes and what evidence there is that she did the shoes at his direction, and if she did it to help him, but it wasn't at his direction. I'm just targeting the standard for admissibility as conscious of guilt.
Well, and again, respectfully, I would suggest there is a lot of evidence that showed he had the means, not just the means because of somebody who was ready, willing, and able to do it, but in fact was doing it and had done it in the past and was doing it through the course of this investigation. And equally, there's two other pairs of shoes there, the Wallace shoes, the Ortiz shoes. And to the extent that those shoes exist, and again, what is her statement from her own mouth in a conversation with the defendant? I'm keeping your things, I'm leaving them, they're there. And then we then go and do a search warrant, and guess what? They're not there. And not only is his pair not there, the other two pairs are not there. So again, I would respectfully suggest that where there has been a prior history of, you know, using her, by his own words, she does what I want her to do, and then there's the history of him having used her in that way to destroy, to specifically sending text messages to get rid of the box, then the phone call that he calls in by her own statements before the grand jury. He told her, go down, get this box, get rid of it. She does that. And then the phone evidence that puts her into driving into Rhode Island and making false statements about where she had gone at that time, I think it's an easy inference.
Your Honor, I think the court has focused on an important issue. We would like to file something on this issue, which we can do by tomorrow. We would like an opportunity to file
Well,
something.
really, if there's not going to be any limiting instruction while the witness testifies,
That's not going to happen today, Your Honor.
then...
My understanding is we're not going to have a witness this afternoon who's, at this point, who's going to testify about shoes.
Oh, I thought that's why we were keeping
Well,
the jury
apparently,
waiting. I would have done this at 4 and not
You're right,
now.
Your Honor, Mr. McCauley apparently changed his mind about the order of witnesses. That's my understanding.
I mean, I really wish you had let me know, because we've had jurors sitting patiently for 30 minutes. I would have done this at 4 o'clock and not had them waiting. I only did it at 2 because it's been indicated it needed to be done before a witness this afternoon. But if the witness is not going to be testifying today, then no need to decide whether I do or don't need to give a limiting instruction. Let's bring the jurors down promptly.